Hello, this is Alexander Cross, Criminal Defense here in the San Francisco Bay Area. If you'd like to learn more about criminal defense, don't forget to subscribe to our channel, Law Offices of Cross and Associates, and feel free to ask questions in the comment section below so that we may respond in the future with more videos for you. So we received an interesting inquiry here on our YouTube channel. This has to do with somebody who was accused of an assault. Let's see right here. My son was accused of assaulting a person in a parking lot. 5 years ago, he was charged with attempted robbery. Okay, well, regarding that case 5 years ago, yeah, I know that he was charged with the attempted robbery, but was he convicted of it? If he was convicted of it, well, then that attempted robbery would be a prior. And any case that is a prior is a case that the DA will be able to use against your son in court at a trial. They'll be able to show that you have a propensity, or that your son has a propensity for violent activity. Assault does not require actual physical contact. Simply putting somebody in apprehension of suffering harm is enough for you to be charged with assault, which would be a violation of Penal Code Section 240, which carries up to 6 months in the county jail. Remember, the actual contact, that's the battery. That's why people always say assault and battery. They're two separate things. Assault is putting somebody in apprehension of suffering said battery in question. In a case like this, obviously, you have to order all the evidence. If there's any recordings, it'd be great. But, you know, it's really, really difficult when somebody already has a violent prior, especially a conviction, because if you take this case to a jury trial, the DA will be able to use that against your son to be able to say that this kid has a propensity for violence. And if what is in the current report is very similar to what was in the previous report, and if they're trying to potentially imply that maybe this was a second robbery, well, then that would not really boast very well for your son. You really need to talk to your attorney, or rather your son needs to talk to his attorney, to really balance what the risk is. To balance what the risk is between potentially taking this case to a jury trial or having a conversation with the district attorney's office to see if this could be resolved by way of a plea deal. Regardless, if you'd like to learn more about criminal defense here in the San Francisco Bay Area, don't forget to subscribe to our channel, Law Offices of Cross and Associates, and feel free to ask questions in the comment section below so that we may respond in the future with more videos for you. But if you've been accused of a crime here in the San Francisco Bay Area and need a representation, give us a call for a free consultation at 1-800-862-7677. Once again, 1-800-862-7677. On our next video, we're going to be discussing the case of somebody who was fleeing from the police while being intoxicated. Criminal lawyer, criminal lawyers, DUI attorney, DUI attorneys, criminal attorney, criminal attorneys, DUI lawyer, DUI lawyers.